intellectual property. More regarding IPR, what is, as per your, what is intellectual property? Anybody? Applicable for new syllabus students. If there's any old syllabus, you have a choice of you can log off, or in case if you want to attend, you can continue attending. What is intellectual property rights? What do you all know about intellectual property rights? Anybody? Done by human mind. It's a creation done by human mind. Yes, it requires a lot of intellect to prepare a certain object or to write a certain book. And based on that, because you use your intellect, you have certain rights that the government gives you. Now, you have separate frameworks. You have laws for intellectual properties. You've got Patent Act, you've got Trademarks Act, you've got Copyrights Act, you've got Design Act, and you've got Geographical Indications Registration and Protection Act. Now, all these five is what you will do individually. We will see individually of patents, trademarks, copyrights, Design Act, and geographical indications. Now, all these are examples of trademarks. All these are of IPR, so intellectual property rights. All of these acts come under intellectual property rights. Now, what is the nature of an intellectual property? It is nothing but it's an intangible right. So, what is intangible? What is intangible?
Which cannot be seen and touched.
Yes. So the rights that you get from the intellectual property is a right that you cannot see, you cannot touch. It is something that you own. You own that particular right, and if anybody does any against your right, you have the right to sue. Now that is your right. So basically, your rights that you have, it is intangible. You cannot see it. One second. See the particular rights of what you have. Now, right to sue, it is something that in case if you have now if you've taken a patent in your name, you've taken a trademark, now you have written a book or you've written a song, you can get a patent in that particular for that particular book, or if you've done that is copyrights, songs get copyrights. If you have invented a particular medicine, or if you've invented a particular machine, you can get patent for the entire process. Now, what happens to that if you get your patent right? If you have, if you've received a patent in your name, you have a right to sue. So anybody who's using it without your permission, you have a right to sue that particular person. Now, their right and duties are next. So you have a particular, you have a set of rights and duties. We will see it individually for all the separate for all the acts. We will see what are the rights and the duties. But simple like create, copy, sell, all of that is allowed for a person who received any particular intellectual property in their name. So if it's patent, if it's copyrights, if it's geographical indications, now all of that you have a certain rights and duties. Like you can outsource your book. Now many of them sell their book. That is called royalty. You will get, if anybody copies your book or wants to publish your book, you will get some royalty for every book that you sell. So that's one example of rights and duties. Now next is the exhaustion of rights. So what happens is after a particular time limit, so you have years, you have number of years, you have 20 years, 25 years, till death, after death, all of that, you have particular you have certain what do you say? You have certain importance on that particular book or that particular song. So what happens after 20 years? So there are certain rights. We will see it in individually, but there are certain rights that even after 20 years you can continue it till you stay alive, and then afterwards you die. And then you have certain laws, you have laws saying that for 60 years you will get entire you will have the entire right on that particular book, but after that it will become a public property. So say a machine, now for 20 years you have patent rights on that machine, no one else can use that machine, but after 20 years anybody can use that machine. So exhaustion of rights. So after a particular time all your rights gets exhausted. Then is your dynamism. Dynamism is nothing but it's a continued process. So it is like you expand, your technology is expanding. So whatever you have created, whatever patent right you've created, if someone expands on top of that, if someone does something, some research on whatever you've done, that is also allowed in the intellectual property rights. Now, coexistence of different rights. Now, say if it is a particular, if it's a particular item, say if it's a trademark, you can register it as a trademark. You can register it as a copyright. You can register it as mark ID. There are various things. So for one product itself, you can register into multiple intellectual property rights under any law. So this is the nature of intellectual property. So there are 6 types of natures of what is an IP. Any doubts? Anybody? Any doubts so far?
Ma'am, for exhausting, ma'am, exhaustion of rights, can
Yes.
we reclaim after 20 years, ma'am? Like renewal?
So there are certain. So we saw that 5 6 laws, right? So there are certain cases where it is allowed to renew every 5 years. But so once we go in individually, you will know what can be renewed. You will come to know what cannot be renewed. So once you're studying, when we are studying it in detail, we'll come to know what we'll get into the details. But there are certain laws, intellectual properties. After a certain period, you cannot renew it. It'll become exhausted. So that means the public can use it as a normal product. So it will come out in the market and anybody can use it. You don't have to pay any royalty to it.
Okay, ma'am.
Registering, how many years how many months it will take, what documentations is given, all of that, it is there in the policy. Legal and registration framework. It is IPR laws. Everything has got separate IPR laws. So creation of the framework is applicable. Administration and management. Again, the whole administration process where investigation goes through. We will see all the steps individually, but there are investigation. There are how they pass on, how they approve patents. Now all that is there as per the National Intellectual Rights Policy. Now commercializations of IPR. When somebody makes an IPR, they try to commercialize it. And when they commercialize it, the person who has got the patent will get certain royalty amounts. So basically, it is commercial for both of you. So if you have created something, it is benefit for you because you're getting money, and it is beneficial for the company who is using it also. There is enforcement and adjudication. Now, if there's any issue with any of the rights, intellectual property rights, you can always go to the tribunal. You can always adjudicate. There are tribunals. There are there are high courts. There are courts, special courts. All of that we'll go through for each law. And then there is human capital development. So basically, when a patent is created, You are creating job markets, you are teaching other people, you are trying to train other people how to use that particular product, you are trying to reproduce that product multiple times. So if it's a machine, you're trying to build similar products of that machine to help the manufacturing of a factory useful. So because of that, you're training people, there is a full IP department itself. So you're giving, basically, as per the policy, you're giving some job opportunities to people as well. Anybody's got any doubts? Of patents. Now, what is patent? Do you all know what is patent? You all would have heard the terminology patent. So, what is patent? So, patent, there's an act, Patent Act 1970, and there are rules 2003. So there are one act and one rules that we are going to study. Now, basically, what is a patent? It is nothing but it is a right, statutory right for an invention granted for a specific limited time period to the patentee. If I have manufactured a particular machine, now I have invented a particular machine, I will get patent right. If patent is granted, I will get the right for a particular limited period. So that's called a patent. And if I am applying a patent, I am called a patentee. Now, whatever I have invented, I will have to give full details of everything, what I have used, how I have made it, how I have made the machine, what is the use of making that machine. If I sell, if I sell the product, how much I will sell it. If I sell the machine, how much will I sell it for. If any parts are imported, you will have to tell that also. You will have to give every step by step process of how you have manufactured the process. Now all that you have to give in an application form when you're filing the patent for a particular product. Now, for a patent, you have the monopoly granted. So once a patent right has been filed, now if I have made a machine, I have got the patent right for that. It is my machinery. Anybody uses it will have to pay me royalty. You, without my permission, you cannot use any of the product, whatever I have created. You cannot use the machine. You cannot create your own machine without the permission from me. Now, again, it is basically something that is created newly. So you can't just now, for example, a chemical. You can't just add another chemical and say, okay, I've added one chemical and the whole product. Okay, so basically, simple example is a machinery. Now, biscuit making machinery. Now, you just add another and you say biscuits are arranged stack wise so that it's easy for packing. Now, that is not an invention. You can't just say by entire biscuit making machinery itself is automated. You can't just say I have created one machine to put one biscuit on top of the other. That is not possible. It is nothing that you've created out of the box. What if you have created another machine specifically for quality check, quantity check? You've created a machine to do that. It's all automation. Then that can be patented because that's something that normal factories do not use it. So basically, it is a process. It is a completely new process that you have invented, and it is used for an industrial purpose. So you can't just I can't randomly make something at home and say, see, I have made something, I want patent right for it. It is not possible. I have to use it in an industrial setup. That's when the patent is given importance. Now, Section 21M of the Patents Act defines the term patent to mean a patent for any invention granted under Patents Act. So basically, that's the definition which is there. So any invention that you've created, a patent will be granted as per the Patent Act. Anybody's got any doubt? Now, what is the advantages of patents is now, if I have registered my patent, now I have invented a machine which is not which is exclusive for my factory, and no one has ever created that automated machine. I have created that. Now what are the advantages that I have? Now I have the complete right to restrict outsiders from making that machine. Now if you want to use that machine, you have to buy it from me. I will make it and give it to you. If I'm interested, I'll make it and give it to you, but you'll have to pay me. But you cannot create another machine like what I have created. So that's my exclusive right on the machinery. Now, anybody who uses my machinery, I can file a case. I can put an injunction. I can ask for compensation. I can ask settlement. I can even put the person into jail. Now, those are the remedies. So, it's a very serious offense if you use something that other person has invented. Now, patentee can commercially exploit or pitch his creation to any skilled individual, conceal, permit to him abuse his item in a way that purposely likewise benefit when along with the lines. Now I have the right to give my product to whoever I want for a particular royalty amount. So I have the right to give, saying I can lease my machinery, I can lease my ideas. I can, tell that you can use it for 10 years. After that, you don't have any right to use my machinery, to use my method. I can tell like that and I can get benefit out of it. So both the parties get benefits out of it. The holder of the exclusive patent permit can also avail the rights given to the patentee. So basically, if I am giving anybody a right, if somebody's bought the patent right from me, now Mr. B has purchased it from me, Mr. B also has that right to use it for those many years. Now, for those many years, he can also, if someone else tries to use that machinery, he can file a case on that. So he's got the right of the patentee only. A patentee gets the privilege to make changes in and alterations of an invention depicted or undercovered in total determination of the primary innovation. So basically, if I have made a particular product, I have the right to innovate it then and there. So I can keep improving it. I can keep making changes to what I have invented. Okay, anyone's got any doubt? So remember it. You don't have to remember it A, B, C, D versions types. You can remember it as however you remember. But this is something which is very, very important in patents. So there are multiple things, but this is one question that I'm sure will come. Now we don't have previous question papers, but I'm sure this question is very important. Now, what are not inventions? There are till O. Okay, so try to remember at least 3/4. If you remember all, it's good, beneficial for you all. At least 3/4 you have to remember. First one, invention which is ferocious or which claims anything obviously contrary to well-established natural laws. So basically, if something is already existing, if there is an already law onto it, if there is anything which is in nature, you can't just claim anything which is so basically, if there is I'm just giving you an example. If there's this old type of grinding machine where you take your hand and you keep rolling it, now you add for that particular thing, you will add one stick and you'll put water, and then you'll say, see, I've invented something where automatically water will go. Now that's not called an invention. An invention is the primary and intended use of the commercial exploitation for which could be contrary to public order or morality, or to human life, animal, plant life, health. So whatever you have created is against the human, animal. It will spoil the human, animal life. All that, those types cannot be called inventions. A mere discovery of a scientific principle or a formulation of an abstract theory, discovery of any living thing or non-living thing substances occurring in nature. Now you keep looking at a plant and then you realize there is some type of worm. Now it's already existing. Just because you have discovered that, oh, this worm is there, it doesn't become an invention. It cannot be patented. A mere discovery of a new form of a known substance which does not result in an enhancement of a known efficiency. This can be for any process, any mechanism, apparatus, okay. So basically, there is a process which is already known. There is a process which you know what is the start, what is the end. You just add something in between and tell I have invented. It is not possible. You need to make something new completely. A substance obtained by a mere admixture resulting only in the aggregation of the properties cannot be called as a invention. So basically, in chemistry only, or say metals, you just add two, three metals, you just add two, three chemicals and say, oh, I made something. That is not possible. That is not allowed. So basically, you're just mixing everything. So there is already a formula. You can't just put back first, put the last formula, put the last chemical first, first chemical last, and tell you made something. That is not possible. The mere arrangement or rearrangement or duplication of known devices or functional. So basically, I had given an example of how to make a biscuit factory. Now there are processes of making a biscuit. There's a process of making biscuits. Now you can't just tell, okay, I will so basically first you mix the flour and then you will put you there'll be flour, there'll be sugar, there'll be cocoa powder, there'll be sugar, I mean chocolate powder, vanilla essence, all of that will you can make cookies. Now you can't tell first I will add sugar, I will add oil, and then I will add sugar, I will add atta. Just by mixing the processes, you cannot say that you have invented something. A method of agriculture or horticulture cannot be called an invention because agriculture and horticulture is something common to the nation. It is like farming, a particular you're doing farming or type of farming. So if you've invented something of that, it needs to be beneficial for the entire country. So that's why it cannot be called invention. Any process for the medical, surgical, and any other treatment cannot be patented. Now, a simple example is COVID. When COVID came, they came out with vaccinations. Now, that cannot be then that cannot be patented because it is done something for a treatment of an human being to make a particular, it is a need. So you cannot, whoever did patent of, whoever invented COVID vaccination, they cannot take patent on them. Plants, animals, seeds, any microorganisms, species, all that cannot be patented. If you found out a different form of dinosaur, if you have found out one insect, a different type of seed where you can grow avocados or peaches and all that, you cannot take patent for that. A mathematical or business method or a computer program as per se algorithms, you cannot. A literally dramatic musical artistic work creation whatsoever, including cinematography work and television production. Now you cannot patent it, but you can copyright it. Copyright, we'll see copyrights later, but all this cannot be patented. A mere scheme or rule, method of performing mental act or method of playing a game. Now you invent or playing a game. You've invented, say, a rummy, Scrabble. You cannot patent such kind of games. A presentation of information. Now, if I make this PPT, I cannot I cannot apply for a patent on the PPT. So, any presentation you cannot apply a PPT. Topography of integrated circuits, if you're making any circuits, it is not patentable. An invention which is in the effect of a traditional knowledge Basically, it's a duplication. So many years back, they have used the particular method in the olden days. You cannot patent that particular knowledge. So if you've used that and if you've tried to make something, it is not patentable. Again, anything related to atomic energy will also not be patentable. Anyone's got any doubt so far in middle? Let's move forward. What is the criteria of patentability? It needs to be novel. That means it needs to be, genuine. You have to make it, and you need to discover it. You should have made it. It needs to be a fresh idea. Basically, all of that. It needs to be an inventive step. It must not be non-obvious. So basically, it must be non-obvious. Basically, anybody cannot guess how that is made, how the machinery is made. It has to have some invention in it. It should be capable of industrial application. I cannot just make something and say I made it at home. It needs to be used in an industrial. It should not attract the provision of Section 3 and 4 of the Patents Act. Now, we will see that in the later on. Now, what is the procedure of applying for a patent? First, you need to file an application. We will go into the details. In the next class, but let's see how it is. First, you file for patent application. Then that is published after 18 months. So basically, gets all your details you submit. Then it goes into the book, saying it goes into the public domain, saying that someone has applied for this patent and this is the process. So they publish it. Pre-grant. So when they are publishing it, they give you a grant. They give other people a grant or a representation by any person to claim on it, saying if someone already got a patent and someone else is applying for another patent, a person can always object it. A request for examination, if the authorities feel that someone has wrongfully applied for a patent, an examination will happen. They will check all the processes, what is being used, and whether you need to grant or refuse the patent. They will check publication of the grant patent. So whatever patent has been granted, it will be published. Post grant opposition to grant patent. So now it's all, you already got the patent. Say in future someone comes back and says this person has cheated and got the patent, then the the authority has a right to oppose it. So you can oppose the patent at any given point of time. So at that time, the controller will have the right to check and cancel the patent that has been given. So this is just a general structure of what it is from applying for a patent to granting of a patent. And in case if someone opposes it, you have a decision by a controller to cancel the particular patent. Now, who can apply for a patent? Any person claiming to be the true and the first inventor of the invention. So if I have invented something, I can apply for a patent. By any person, assignee of the person claiming to be the true and first owner. Now, if I am say handicapped, if I cannot apply for a patent myself, then I can appoint someone else on behalf of whom they can, on my behalf, they can apply for the patent in my name. So that he or she is called an assignee. By a legal representation of any deceased person immediately before his death was entitled to make such application. Now, say example, whoever's applying for a patent, he applied for a patent and then he passed away. What happens then is the entire process has to be completed. Then the legal representative will have the right to continue and apply and receive all the benefits under the Patent Act. So these three are the people who can apply for patent. Anyone's got any doubt?